Hello and welcome back to Heights Library's podcast, Unpacking 1619, where you can explore the interviews we've collected with scholars from around the country, in which we unpack topics relating to race in America. I'm your host, John Pichet, and I'm thrilled to share these interviews with you here. On this episode of Unpacking 1619, I talked to Professor Jocelyn Simonson, former New York City public defender, and currently she's teaching at the Brooklyn Law School. She discusses her book, Radical Acts of Justice, which looks at several ways activists and volunteers engage in resistance of mass incarceration. Groups that offer bail funding, court watching, and engage in participatory defense are changing criminal justice so it is more transparent, fair, and democratic. Here's our conversation from February 27th, 2024.
Hi, my name is Jocelyn Simonson. I'm a professor at Brooklyn Law School and the author of Radical Acts of Justice, How Ordinary People Are Dismantling Mass Incarceration.
Well, thank you for joining us and talking about your book. I begin all these interviews the same way, which is, how did you come to this topic, and researching this book, what did you learn, if anything?
Yeah, so I'm a law professor now. Before becoming a law professor, I was a public defender in New York City in the Bronx, and now I'm here in Brooklyn in New York City. And as a public defender, I represented actually thousands of people in the course of 5 years. And I worked within a criminal court system where I was representing all poor people of color in the Bronx, and seeing this churning of people through a system that wasn't helping them and didn't feel like it was helping the community. But my experience as a public defender was one, not of helplessness, one-on-one, like I felt like I could fight for individuals, but of a helplessness in the sense of broader change and reform. And so when I left practice to become a law professor, now I teach and write and try to find the hope. So I write about people who are collectively resisting the system or helping each other, or finding ways to make change and try to live out visions of a world in which we don't always use the police in cages to try to keep each other safe and get people to flourish. And so that means I research and write about groups that are doing things like that, but I also lawyer in support of them. So I'm on the advisory board of a group called the Community Justice Exchange, which helps run the National Bail Fund Network, among other things, and we can talk about bail funds. But I also, in writing this book, did a lot of interviews and talks with people who are doing on-the-ground organizing, using tactics that I had previously written about kind of from a distance. Like, I don't know if anyone has read a law review article, but law review articles that law professors write are incredibly dense, use a lot of legalese, and then have a lot of footnotes. So it'll be like half words above the line and then half footnotes. And I wrote about community bail funds, for example. I wrote about their power in law review articles, which I love to do, right? It's a form of scholarship that I love. But this book was different. I wanted to say, I intellectually have a sense that community bail funds are incredibly powerful and incredibly important, but I want to talk to people on the ground who are doing that work. And so I did. And I did those interviews right around when COVID first hit. And so a lot of it was virtual, which is hard in some ways, but also meant I could sort of take time and connect with people in all different places around the country. Interview people multiple times. There are people who are really generous with their time over hours and hours. And so then I tried in the book to tell the stories of the people and the groups who I was talking to in a way that hopefully brings out some of the importance through hearing about the power of these groups rather than otherwise. And what I learned is that the tactics I was studying and write about felt to me even more inspiring than I had thought about them intellectually. I'm kind of a right-brained intellectual person. And I found myself really moved multiple times when talking to people. And so I tried to bring some of that energy into the writing of the book.
Well, thank you. I had a problem there for a second. So I guess to begin the discussion on, before we get into some of the points of resistance and how people are kind of trying to change the system, Maybe you could give us an overview of what's the problem with our legal system. And I was really fascinated by your discussion of the way you kind of unpacked the people as a concept, as a way of entering into the ideology. And I would love for you to talk about that specifically.
Yeah. I initially had an opening chapter in the book in which I described what mass incarceration is before writing the rest of the book about how people are dismantling it, like to really describe the problems with it. And I decided not to do that because I wanted to use the work that these groups were doing as a way to show what the problem with mass incarceration is by showing this other way of thinking about it. And so if we think about the problems of the system as seen from the view of groups that are trying to bail people out of jail, trying to work together to support each other in their own communities without the police, watching what's happened in court, thinking about their city budgets, those are some of the things that I talk about in the book. The problem of the criminal court system does not become those procedures aren't fair or the sentences they're giving aren't correct. The problem is, I don't know if bigger is the right word, but the problem is different than that. The problem is we are talking about communities of people who are living in precarity, meaning they're poor or they don't always have rent or enough to pay. There's people harm each other. People don't always have what they need to survive. And the problem becomes using the police, prosecution, courts, and jails, and all the resources that require to try to keep communities safe and help them thrive, versus using other tools and supporting people and helping them support each other. And the reason the people plays into this is because so often this part of it, the policing and especially the prosecution in the courtroom, is done in the name of the community and in the name of the people. Sometimes this is literal. So you can think about the opening of Law and Order, which tells us that the people are represented by two parties, right? It's the police and the prosecution. Or as many probably know, the case captions of a lot of cases are, in New York, for example, the people of the state of New York versus Jocelyn Simonson. And so when I was practicing as a public defender, prosecutors literally refer to themselves as the people. Like the judge would say, "Good morning, counselor," or "Good morning, Miss Simonson," to me, and "Good morning, people," to the prosecutor. Or it'd be like, where are the people? The people are in the bathroom. And by that, we mean the prosecutor. And so when you're talking like that, it just becomes how you talk. I call them the people too. It can seem silly, but if you take a step back, it's actually saying that all of these prosecutions are being done in some democratic sense for the benefit of the people. And that means the literal people who are being prosecuted, and more important, at least in my book, the people who are supporting them or sitting in the courtroom are not the people, right? So if we start to look at these other people who don't approve of all the prosecutions, are being prosecuted, are supporting them, or even just are there to watch in a quizzical, critical way, rather than this is all being done in my name, and who are saying, wait a minute, how is this being done in my name? Then that terminology of the people becomes problematic. And so one of the things that's exciting about these collective moments of resistance that I write about is that they are really pulling the rug out from under the claim that when we prosecute someone and then we put them in a cage because we say they've done something against the law, we're doing that in the name of the people. It's like, no, you're doing that in the name of some people. But actually, this courtroom is full of literal people whose name you're not doing that in. And it's not pure semantics. The people doing this work feel the power of that challenge to the violence of criminal court.
I'm having some issues with my own. So I think that your book covers four major places of resistance, and I want to start with community bail funds, but I hope to get to court watching, defense, participatory defense, community defense, and how budgeting is being challenged. But would you explain why bail funding is such an important piece of resistance, because I think a lot of people don't understand layperson. Like, I've never really had any court interaction. I just assume everyone can get out on bail, and that's not the case, is it?
Well, the concept of bail would mean that that is the case. So the idea of money bail and the way it used to be practiced is that it's a way to release people when they've been charged in a crime so that they will come back to court. So you might say you've been arrested and charged with a crime, theft, and we're going to release you if you pay us $500. And if you don't come back to court to face these charges, then you're not going to get your $500 back. So the $500 becomes an incentive to come back. And if you think of it that way, there's some logic to it. But if you look at how money bail is actually used, it's used as a method of incarceration. So at any moment, including like right now as we sit here, there are well over 400,000 people sitting in jails who have not been convicted of anything. Their charges are pending. And most of them are sitting in those jails because money bail has been set beyond what they can afford, often as low as $500. But if you don't have any money, then it doesn't matter if the bail is $500 or $5,000. It's the same thing as being told we're going to start your incarceration now. And people who do have a lot of experience with courts experience bail that way. Bail is a way to keep somebody in jail. Or maybe bail is a way to extract money from somebody's mom or their grandma who has to put up their house in order for someone to come out, maybe. And so and just the other thing about the traditional way of thinking about it, even now, is that we might think about bail as something that either the person pays or their family pays, because they're the ones with like a stake in this person coming back to court. They're vouching for this person. Okay, now here comes a group and they say, we're going to collect money. We're going to ask people to donate to us. And then we're going to pay bail for strangers, for people we don't know, but who we think of as part of our community, right? So it's often called a community bail fund. Maybe it's our neighborhood, maybe it's our county, maybe it's our whole metro area. And we're going to pay bail for that person because bail is being set in our name. And under bail statutes, the reason we're doing it is to protect the community. And we're the community and we're the people. And we don't feel safer when that person's in jail. So instead, we think that the world is safer. And statistics show if someone sits in jail for just 2 days, they're more likely to be arrested in the future, right? So even if you think of arrests as indicators of dangerousness, you're actually creating less safety when you put somebody in jail, which makes sense because if you're able to be out, go to work, be in your house, have the support of your friends and family, maybe see your social worker or whatever supports you need, you are going to be less likely to hurt other people. And so a group says, we actually think that community safety lies on the side of freedom. And so we're going to pay bail for somebody. That's the concept. But now they come into a court and they're physically going to the bail window and they're paying bail in the name of the community. And then the next day they're doing it again for somebody else. And the next day they're doing it again for somebody else. And then when those people come back to court, the money comes back to them and it becomes this rotating, continuous, and it's not every day, right? It actually takes a lot of resources. It becomes a continuous way to actually say something really powerful about jail, about money bail, and about the criminal court system itself. And that is powerful. Bail funds are able to tell collective stories over time of here's what we found when we bail people out. We found they don't tend to get arrested at any rate different than anyone else. And we found a lot of cases where they were able to meet with their attorney and fight their cases. A lot of times the charges get dropped instead of pleading guilty. In New York City, where I live, when there were calls, 6-7 years ago to close Rikers Island and to end money bail, politicians were constantly naming our bail funds as the things that were showing us the injustice of money bail. In Illinois, where they recently ended money bond, the Chicago Community Bond Fund was a crucial part of broader political efforts to end money bond in the state. So they're the only state that has done this. And so community bail funds are doing these two things at once. One is that they're literally helping free people, right? They're literally freeing people. But they're also making this broader statement that combines the sense of democracy and community with this critique of the system and its claims for what it does. And the way I try to explain that is by telling the stories of bail funds and what they do, because I don't think it's intuitive. I think it's something that you have to sort of see and feel. And part of the reason we know that bail funds are so powerful is that the court system absolutely loathes them, hates them, even when people still come back to court. So I tell the story in a book of a judge here in the Bronx named Ralph Fabrizio, who became absolutely irate when someone just walked into a courtroom free, having hurt nobody, because a community bail fund had paid bail for him. He was like, who set bail for this man? And he held up his folder to say, look, on the folder, it says he's indigent. He shouldn't be able to pay that money. He was so angry because it was disrupting how the court system works. And if we stop and ask what his anger was about, like it wasn't about worrying that anyone would get harmed. It was just about disrupting the system in the name of the community and feeling that threat. And I have to say, one thing that's scaring me is that even when I finished writing this book, it was published in August 2023, I wrote in the book about how the system is pushing back against bail funds. But there have, even in the last 6 months, been 4 different states that have legislation pending that would either outlaw entirely or really limit what bail funds can do. And these are in states where bail funds have become really powerful forces. So I actually, today, I meant to say this, I have an op-ed out in Time magazine that John Legend wrote with me. It's co-written with John Legend, which is fun, saying like, pay attention to these laws, they're really dangerous. And we should pay attention to them, they're really dangerous, but they also show us how powerful the work is.
Well, and I would argue, I guess, and I think you argue very effectively too, that by redefining community, you're also redefining the power of the court. And one of the major powers of the court is punitive. And it's punitive so it's punishment at every level. Because, I mean, with people with court cases, it's a full-time, or it's like having 2 full-time jobs, managing the schedule, managing the workload, managing your time, and it becomes all-inclusive, right? So I would love now to move into court watching as another way of challenging that dynamic, that punitive dynamic of the courtroom. So if we're talking about letting people out previously, now we're talking about what happens inside those chambers, right?
Yeah. So community bail funds, which I have been talking about, have really in the last 10 years taken off from 3 or 4 around to 2016 to now well over 100 throughout the country. And then we can also trace a similar trajectory. Well, the numbers aren't necessarily quite as high in efforts to do organized court watching. So what that means, and sometimes it's the same groups and communities doing the work. So that means that a group of people will come and sit in a criminal courtroom, and not a criminal courtroom where like Donald Trump is on trial, right? Not like a already crowded courtroom that the newspapers, it's a famous trial, the newspapers are writing about it, or a serial killer or what have you. Instead, they're going into these ordinary courtrooms that are crowded with people, and where things like bail hearings, traffic tickets, warrants, arraignments, or just simply adjournments and guilty pleas are happening. And those things, it turns out, actually make up our so-called criminal justice system, right? It's Donald Trump's case is one in just millions and millions. And it's the others that these groups are focusing on. And they will sit in court and watch what's happening, write about it on social media, and then collect stories and reports about what they see. It sounds simple, but the court system experiences it as incredibly subversive, and the people doing it experience it as incredibly powerful, because ordinarily, without a court watching group there, and often they're wearing matching t-shirts and holding clipboards, or sometimes now, the initial upsurge in COVID, sometimes virtually, they can call in or watch what's happening. Ordinarily, nobody is watching if they don't already have a case on that day, right? And so most people in that courtroom are part of the court apparatus. So there's prosecutors and defense attorneys and judges. Then there are a lot of other people, like a stenographer and caseworkers. There are court officers with guns. There are corrections officers with guns. There are cages, jail holding cells right outside the courtroom, sometimes inside the courtroom. And it's a place where things happen really quickly, but those quick things are actually life-changing moments, right? So someone comes in on a traffic ticket. It turns out they haven't paid $500 and they're quickly put in jail for 10 days. Like that can happen really fast in language that we don't understand. But someone's just been put in a cage for 10 days, right? That could change the course of their life. It could even lead to their death. Deaths in jail are really high right now, maybe as high as they've ever been. And so normally that goes unnoticed, not unwatched because people are technically there, but really unnoticed, unremarked upon, and the power of the people doing those things is not challenged. It turns out there's a First Amendment right to sit inside criminal courtrooms, so that helps support the work of court watchers and many other courtrooms. And so if you come sit in there and watch what's happening and write it down on a clipboard and then tweet about some things that you see, prosecutors are incredibly frazzled because they're not used to being watched. Like here in New York City, the Manhattan DA is often a famous figure, right? The Manhattan DA made an announcement of we are going to stop asking for jail time on certain kinds of drug offenses, and we're going to stop prosecuting turnstile jumps, right? That's some kind of announcement. But they didn't know that court watchers were going to come watch and see if that actually was true. So it changed, and they got really frustrated when court watchers started tweeting what they were seeing in court and suggesting or stating that what they were seeing was not the same as what the district attorney said they were going to do. They really pushed back. They couldn't say you can't be here because there's a constitutional right to be here. But it is very clear that they were uncomfortable being watched and reported on, even though they are the people of the state of New York, right, on the record. And so sometimes it's tweets and quick things. Sometimes it's feeling the power, watching what you're seeing, and then debriefing about it afterwards and engaging in community education to better understand the system that so often we are not watching. And then sometimes, or often, court watching efforts are going to systematically collect information over time because court systems are not publishing on their websites lots of information for us. So Philadelphia would be a good example of this, or Chicago. Court watchers came and they watched bail hearings every day for a set period of time, for weeks. And then they were able to write a report saying, they're not telling us, but we can tell you, here's what's happening with bail in our criminal courtroom. And then that report led the court system to literally change their bail rules because it puts pressure on them when, sorry, we didn't know we were doing these things somehow. So the power of court watching, on the one hand, it's just a tactic. All of these things it's just a way to collectively do something. But what we're seeing across the country is that the feeling of court watching and being the experts and also just being the people, right? You're doing this in our name and we're here to watch it, becomes this powerful moment of democracy in some way.
Well, could you also, because you mentioned it a couple of times, and I think that it's probably important to kind of unpack a little bit, which is the violence that's inherent in the courtroom. As you kind of alluded to, there's this design of courtrooms that actually is violent. And I don't think most people, I mean, I noticed people in handcuffs and that kind of stuff, but could you talk more about how, when you say people being put in cages, that sounds very dramatic, but I think it is what's happening. And the violence in the courtroom.
Yeah, I do use the word cages to be dramatic in some way. It is literally a description of what jail cells are, right? You could also say put in jail. You could say incarcerate. That word bothers me. It's just so like impersonal. It's like when we call people individuals instead of people. So any number of ways would be accurate. I don't think there's anything wrong with saying jail. But yeah, I think the invocation of cages, which are often used for animals, right, in addition to people, helps get at part of what is happening in this courtroom that we don't always think about. Because you walk into a courtroom and some of them are gross and dirty and some of them are beautiful and new, but they still have some things in common, like rows of benches, an American flag. Sometimes it says, "In God we trust." The judge is often wearing a robe. Sometimes they're sworn in and oyez, oyez at the beginning of the thing. There's some kind of like procedure and decorum, or at least I think in the ideal version of it, there is. You can think of what you see on Law and Order. It might be happening fast, but those Manhattan courtrooms are like wooden and paneled, and there's enormous American flags. There's some kind of sense of ceremony and official, legal, procedural things happening. And the more legal and procedural it seems, with gavels and next case and case numbers being read out loud, the more impersonal it gets, and the more we lose sight of what we're actually doing. Because the criminal court system, listen, even if you think that cages are the best way to treat people who have done something wrong, I don't think that, but even if you think that, hopefully then you think it's actually an important thing to be doing, right? And a thing to do, to take a human being, lock them up. If you think that's the right thing to do, then I think you want it to feel like punishment. It is a violent act. Jails literally kill people, but I'm not even going that far in talking about the violence of it. What I'm trying to do is uncover how just these words set on the record start to mask the importance and what should be really emotional importance of what we do when we charge somebody with a crime, whether or not we send them to jail, when we give them a criminal record, which should be like a really profound thing. And certainly when we incarcerate them, jail them, put them in a cage, whatever words you want to use, I want you to picture this body, this person with brains and feelings being put in a space where they're confined and not free to go. And I think that if somebody believes in incarceration, which many, many, many people do, right? Then I would hope they would believe in it, not by ignoring what we're doing, but by saying, I think those people deserve it, or by subjecting them to that violence, some other good is going to happen. But let's at least acknowledge what we're doing. And when you walk into a courtroom, it can be easy to forget that, unless people are coming in to sit and witness and say, wait a minute, he just sentenced that man to 10 days in jail. That sounds like something important that just happened, but it was literally 5 seconds.
Yeah. And then I think too, there's this perception that there's a lot of trial, and especially trial by jury or a bench trial, whatever you want to have. But I can't remember the statistics, but the plea bargaining is the way of the world, not these days, and courts function on them. So how does participatory defense resistance work in this context of kind of this plea bargaining, statute, state of affairs? And you tell a great story about a guy who is charged, and they find the video footage across the street and that kind of stuff. So why aren't public defenders doing this? And we know why they're not resourced, but I mean, it seems like we have this perception that that's the system that exists. So why would it be necessary for there to be a community-based defense organization?
Yeah, so you're right about plea bargaining. Our current statistics are that well over 95% of cases that end up with a criminal conviction do it through a guilty plea. The number of cases that are trial, though, is less than 5%, because a lot of cases get dismissed. So really only a really, really tiny bit, 1, 2, 3% of prosecutions end in a trial, and certainly end in a trial where there's a jury deciding what happens. Now, I was a trial lawyer. I tried cases in front of juries. I love juries, but we don't have a system of juries. We have a system of pleas. The Supreme Court has even said this. Ours is a system of pleas, not trials. Famous Supreme Court case. And so that means that we can't wait for a jury and for democracy to happen at this moment of having a jury. The way the system works is people are supposed to be guessing at what the evidence would be, or prosecutors are giving offers, plea bargains, like if you plead guilty now, you can have this lower sentence instead of a higher sentence. It's what allows our system to function. And if you read Supreme Court cases about plea bargaining, they will often say, it doesn't really make sense constitutionally, but if we didn't have it, our system couldn't continue. To me, that's a stinky reason to allow something to go forward, but it has become what the Supreme Court, I think, honestly says they're doing, which is to say we have to figure out a way to keep allowing these pleas, or else we wouldn't be able to prosecute the incredible amount of cases that we do. So why do we need participatory defense? I'd say a bunch of reasons, but one of them is that they're coming in to a system in which people are entitled to an attorney in most cases. But our system of public defense is so underfunded that public defenders, and I was one, right? They might be, I'm brilliant. They might be brilliant and wonderful lawyers and kind people and spending as much time as they can, but they're still going to have too many cases and not enough resources to be just, a really wonderful lawyer who can go chase down all of the evidence in a case, especially a small case. So the story you're telling is from Knoxville, Tennessee. This is someone arrested for being loud, disrupting things. Then the police arrest him, and then they say that he resisted arrest. And so they arrest him, and he has a pending case, and he comes to this participatory defense hub, Community Defense of East Tennessee in Knoxville. And what that is a group of people who have been meeting in a church basement for years and years now, right? More than 5 years. And they meet every week, and people with pending cases come and they talk through their cases. They say, what are these charges? What do they mean? What kind of evidence might be out there? What's going to happen at the next court date? How can we fight this case? How can we affect the plea bargains? And people, after their cases are over, keep coming back. So I got the chance to go to Knoxville and talk about the book, which was so fun because they're in this book. And I met, a kid who was 18, and when he was 15, it started going to the hub, and he hasn't had a case in years, and he just goes every week because it's this powerful communal space to be in. And so I tell the story of this man, and this is just, again, a low-level case. And so he has a public defender. His case is probably not that priority. I think there was a plea offer of a misdemeanor, but he said, I didn't do it. And he, along with the hub, was able to push the defense attorney to get some footage from a hotel across the street that showed that he didn't do what the police had said that he did. And so ultimately that case got dismissed. And it wouldn't have gotten dismissed without him understanding his charges, without him having people support him and collectively come with him to the office to ask for that thing. And it's one small moment, but it's actually the beginning of opening up this amazing community organizing in Knoxville, in which, they, in ongoing cases, they'll make video profiles of people to bring to sentencing hearings. They'll observe hearings, they'll observe trials, they'll come to courtrooms, they'll show this communal support at the same time that they are starting to learn how the system works. Again, like most people don't know how criminal court works, and it's not necessarily that you should, but if it's serving the function that the state wants it to, which is like keeping us all safe all the time, or putting people in jail all the time, however you want to think about it, then we should know what's happening. And so as this group starts to become empowered, right, and get the collective knowledge of what's happening, share that knowledge with the world, and then bring that knowledge into the courtroom, it changes the power dynamic in the courtroom. And it becomes not about whether public defenders do a good job. That's just not what participatory defense is about. It's about shifting the power dynamic. It's a lot of them say protect your people is the Participatory Defense Network slogan. Again, going back to this question of who the people are. And so a lot of participatory defense hubs will be part of larger networks that include bail funds, court watching, other groups that are trying to push for community support systems that mirror what participatory defense hubs do, like taking care of each other, asking how people's parents are, giving supports when they need them, finding people drug treatment. Like, it's great they're doing that, but they want the state to be providing those things without using policing and courts. So they're also kind of living out this other understanding of how to keep people safe, which is part of the story I try to tell in the book.
Well, and it's well told, so thank you for doing that. I would like to kind of wrap it up with a question that I think probably people may be having, which is, and I think it goes back to the Supreme Court's decision about bail, saying prevention versus liberty. It should be prevention over liberty. But what do you say to somebody, and what do these community groups, how would they respond to the kind of the accusation that why should we care about criminals? Aren't victims' rights? And like whenever there is let's say a furlough, someone goes out and commits another crime immediately, and then the whole reform just collapses because of this one action. So would you please address that critique and that concern that maybe viewers are having as they're watching this?
Yeah, I think that given our culture and what our papers tell us, it's an understandable question. Why should I care about the criminals? We have a system, they get lawyers, they have rights. And I think one of the things that these groups kind of live out and show us is that if you come from a marginalized communities, criminals aren't strangers. They're like people in your neighborhood who either are being profiled by the police or are living in such a world where stealing is what they feel they need to do to get by or what have you. And so if it's your brother or your sister, maybe you can start to understand how you might care about it. But these groups are saying, I don't have to be related to somebody to care about them. And it turns out that when we show care and support for somebody, they are less likely to do these things that we call crimes in the future. So these groups are showing us that whether you're trying to stop these things from happening in the future, or whether you're trying to address what's happening here, care and love are probably going to get you there. And so maybe we should stop and ask why you don't care, why you don't care. Like, why do we feel hatred for strangers just because we've put them in pinstripes? Instead of showing compassion for somebody who clearly has been in a tough situation. I mean, studies show that not just most, but nearly all people who hurt other people, who act in ways we consider violent, have been hurt before, right? Violence begets violence. And so when somebody does something harmful, we can also pause and go backwards and see what caused that person to be violent, and then try to create a world in which we have less violence because we're treating each other with care, respect, compassion, community, support. And what these groups are showing is that our cities and counties and states can't provide those supports if they're spending all of their money, attention, and resources on policing, prosecution, jails, and prisons. And so it all becomes related to each other. And part of the power of what these groups are doing is they're just literally living it out. They are showing it to us. So yes, it might be true that one person who's released on bail hurt somebody. That's terrible, right? But they're saying, let us tell you about the 1,000 people who were released on bail and not only did not hurt anybody, became less likely to hurt somebody else, and were able to be with these children I'm going to tell you about, go to this job I'm going to tell you about, attend this church that I attend, whatever it might be. They're able to sort of show that over time, there's a broader, more collective way to think about community and safety that involves seeing the humanity in other people rather than labeling them as criminals or monsters.
Yeah, and I think you touched on something really important, which is that the system's designed to disrupt neighborhoods, communities, families. And it goes all the way back to the way the Klan terrorized people after Reconstruction. You go in and you take someone out of the home and you just either kill them or beat them to the point where they're no longer. So you make a really powerful point at the end of the book about how these groups are trying to reinstall democracy into a system that is fundamentally undemocratic.
Yeah, they really do. It's hard to know where to locate democracy, but it can't be that democracy is just voting, especially in our current system where a lot of people can't vote and people who can vote are having their votes suppressed, and we're gerrymandering, and we have the Electoral College. However you think about it, it can't be that our only way to secure democracy is through voting. And it can't be that the only way to secure our democracy is through juries, which is traditionally what we think of the function of juries, because we don't have juries. And so these groups are taking democracy into their hands in a couple of ways. One is they're going into courts, these spaces that are supposed to be democratic moments of justice or possibility or accountability, and they're watching it and they're shifting the power within it, and they're coming out and they're saying that didn't feel like justice in our name. And not only that, we've been supporting each other and have collective understandings of justice that we want you, the court system, the state, to listen to as part of our democracy. And then they're engaging in self-education and conversation in a way that the court system is not doing. And so again, it's this modeling of a different way of relating to each other, which is itself a form of democracy.
Thanks for listening to the Unpacking 1619. For more information on Heights Library's 1619 Project discussion group, or to check out more interviews with scholars, please visit heightslibrary.org. See you next episode, wherever you listen to podcasts.